Yes, Tarang, you may proceed.
So very pleasant good evening to very pleasant good evening to one more present here. I am Tarang Arora, junior coordinator at Just Corpus and the host for today's session. I, on the behalf of whole team of Just Corpus, welcomes you to today's session, which is basically on emergency arbitration in India, a very prominent topic as of now. Before we delve into today's session, I would like to brief you about the Just Corpus and the eminent guest of today's session. So Just Corpus is an edtech platform established in 2020, comprising a collection of legal professionals. This platform aims to consolidate various aspects of law and chains of law under a single umbrella. With an impressive reach of 600K clicks per month on its website, Just Corpus was inspired by the growing needs of law students. As part of its initiative, Just Corpus has introduced an interdisciplinary journal known as Just Corpus Law Journal. Now, turning our focal point towards the very core of today's session, we are privileged to have Dr. Parineeta Goswami as our eminent guest of today's session. So, ma'am is currently working as an assistant professor of law at Manipal University, Jaipur. Ma'am started her career as an assistant professor at SRM University and then she moved to Manipal University, Jaipur. Before her teaching roles, she worked as a research fellow at Rajiv Gandhi National Law University, Patiala, from August 2018 to October 2021. Her primary area of interest lies in bankruptcy laws, insurance laws, arbitration laws, corporate laws, merger and acquisition, insolvency and bankruptcy laws, among others. Her education began in BCom degree from International College of Girls Jaipur in 2011. She has completed a bachelor's from University of Rajasthan in 2014. Later, she pursued LL.M from Amity University, Noida, specializing in corporate banking and insurance laws. She held second position and prestigious award of Shri Baljit Award in Best in Human and Traditional Values Amity University in 2017. In 2018, she successfully cleared U.G.C NET examination and obtained Junior Research Fellowship and Lectureship. She has completed her PhD in law at RGNUL in 2024. She has also authored two books in her name and a very prestigious publication in her name in U.G.C NET and has also a lot of publication in national and international seminars as well. She chaired various national legal events such as ATL competition and motor competition as well. Without further ado, I would like to hand over the floor to ma'am for valuable insights. Over to you, ma'am.
Thank you, Tarang, so much for this introduction, kind introductions. Greeting to each and one of you here who has joined with us as a YouTube viewer for this session on the emergency arbitration in India. Before starting with this lecture, I was just in two lines, I want to explain what is arbitration. Those person who doesn't know about the arbitration. Arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the disputes. So in choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court. So this is the basic meaning of the arbitration. Now, if we come to the point of emergency arbitration, it has emerged as a popular mechanism for parties to obtain the urgent relief from an emergency arbitrator. It refers to an arbitral mechanism that take place before the formation of the main tribunal. So they can deliver urgent interim relief for protecting the assets and evidence that cannot wait for the formation of the tribunal and may otherwise they get altered or lost. So this whole mechanism is based on four founding principles, which are the success on merits, the risk of irreparable harm, the risk of the aggravation of the dispute, and the balance of the equity. So these four are the important goals and the function which we can say this mechanism serves, and it is frequently
People, there's a slight glitch on ma'am's end, so ma'am will be joining within a few seconds.
Am I audible?
Yeah, ma'am, you're audible.
Am I audible, Tarang?
Yeah, ma'am, you're audible.
You are
Yes,
not
ma'am.
audible to me. Wait. Okay, you are not audible to me, but I will start my session again from the beginning. And if you have any message, you can message on the chat box. Okay. So let me start with the again the topic that we are going through today's emergency arbitration in India. Before I start my lecture, I just want to know that what is the basic meaning of arbitration in two lines. Arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decisions on a dispute. Now come back to the emergency arbitration. It has this mechanism has now become as a very popular mechanism for the parties to obtain their urgent relief from an emergency arbitrator. It refers to an arbitral mechanism that takes place from the formation of the main tribunal so they can deliver urgent interim relief for protecting the assets and the evidence that cannot wait for the formation of the tribunal and may they have get lost or they have altered in that whole procedure. So this mechanism is basically based on the four principles. First is that the success on merits. Second, risk of irreparable harm. Third is the risk of aggravation of the dispute and the balance of the equity. So this on these four principles hold emergency arbitration mechanisms. So now, if we go back to the history of the mechanism, emergency arbitrator, how it evolved, how it's come into the in the era, it started from the 1990 when the International Chamber of Commerce has first become the arbitral institution to offer pre-arbitral emergency measures that permitted parties to submit their disputes for, among others, through an emergency arbitrator order. ICC is only one who recognized that during that course of many contracts, particularly the long-term contracts, issue might arise that requires so much urgent responses. So in such limited time, it is very not possible to arrive at any binding decision from a tribunal or a court. So ICC incorporated a pre-arbitral referee procedure so they can provide a temporary resolution to the dispute and lay the foundation for its final settlement. After that, the ICC, the WIPO, the World Intellectual Property Organization, also proposed an amendment to their arbitration rules, and they incorporated the emergency relief mechanism. However, the same did not work until 2014. So in 1999, American Arbitration Association also adopted an optional rules for the emergency measures of protection as parts of their commercial arbitration. So within the next 2 decades, several arbitral institutions realizing the relevance and the importance of the emergency mechanism, which may be incorporated through the rules for the emergency arbitration, and which result in the availability of emergency arbitration become very norm. Whether it is a Singapore Stock Chamber of Commerce, or the Swiss Arbitration Centers, or the Hong Kong Arbitration Center, or the China International Arbitration, almost all have recognized till the 2015. Now, this is the little bit the history part of the emergency arbitration, how it evolved and how it's. What will be the benefits of the emergency arbitration if we don't go for the litigation, or we don't go for the court ordered interim measures? We can go for the interim measures, but what will be the benefit of the emergency arbitrator? First one, that is the experience. An emergency arbitrator is appointed before the constitution of arbitration tribunal, and they have empowered to grant interim orders. So the international arbitral institutions provide whole expedient procedure for interim relief in their rules that must be followed by each and every emergency arbitrator. These rules provide specific time frames for procedure, such as the appointment kaise hoga, what will be the delivery of final orders. Whole things are mentioned in these rules. So by following such procedure, emergency arbitrators are distinguished from the mechanism of the court. This procedure expressly stipulates expedient proceedings so they can grant quick and effective interim relief to their party. A study of the Singapore Arbitration Center also demonstrates that order for a major cases before an emergency arbitrator were rendered within 5 days from the date of request of emergency is perceived, which to be insufficient, or if the court lacks the experience to accommodate a request for interim relief. So in a typical scenario, if we talk about where the issue relates to the multiple jurisdiction, instead of making application to the multiple courts, making just one application to the emergency arbitrator expedite the process. Hence, in countries where courts require excessive procedural formalities and where the working is very slow, parties tend to go for the emergency arbitrator mechanism because they can rely on that, and they can order will be passed on the very speed service, and it's unlike the unconventional courts. Now, what is the second benefit? That is the flexibility. Typically, arbitration rules do not specify any strict standards for the decision-making process in the case of emergency arbitrator. So they generally state that the emergency arbitrator may order any measure, it be necessary, fit, or appropriate. So there is no universal approach to this mechanism, such as the threshold issue, or we can say that the procedural matter, substantive standards, what will be all these are what will be the post arbitration consideration. All these they don't have any such rules and regulation provided in detail. However, in this proceeding emergency arbitration, domestic courts are bound by the laws of the relevant jurisdiction, and they may not have the room to exercise their discretion. Therefore, there is a fair advantage on approaching an arbitrator for over a conventional court, since most arbitration rules leave a considerable amount of discretion to the emergency arbitrators in delivering their order. Now, what will be the third benefit? That the persuasive powers of the arbitrator. It is a very important to choosing the which form of interim measures we are going for. So order for interim relief granted by the arbitrators are very often voluntary complied with, the since a party against whom such an order has been imposed would not want to be seen disobeying such orders before the arbitrator, and they had formulated an opinion on the merits of the case. Also, in certain cases, the arbitrator may draw an adverse inference from the non-compliance of their interim orders by a party, and they can take the same into account while deciding the case and their cost. So whatever the domestic courts grant entry in arbitration would naturally not be rendering decisions on the merits of the case due to the lack of jurisdiction. So opposite party would be less willing to comply with such court orders due to the lack of repercussions of the same. So party requesting interim relief is persuaded to opt for the arbitral proceeding over a domestic over proceeding. There are some other advantages, like that party can invoke emergency arbitration when it involves substantial amount of money, value, and risk, and which urge parties to seek emergency relief due to their urgent and quick nature. Also, in certain cases where the issues relate to several jurisdiction, in which jurisdiction the case will be fall, or application may have to make in multiple courts in several different countries, this can be simply avoided by approaching a tribunal for more interim relief where only one application will have to be made. So in the case of domestic courts, we may not provide the most efficient solution to the problem, and they can result on ineffective forum, or they may use as a require some local counsel or involve other complication arising of domestic procedure. But in the case of EA, we can have that priority over that, because we have the party autonomy, privacy, confidentiality, and transparency. So party autonomy, that is the main founding stone or the cornerstone of him, is the whole mechanism, which must be much like the regular arbitral proceeding. In this case also, emergency arbitration arbitrator can derive its authority from an agreement between the parties. Also, this mechanism governed by the agreement between the parties and the rules that the parties themselves consent. So through this practice of electing rules of arbitration institution that provide whole procedure, parties kon hongi, what will be their exercise, all are their autonomy. Privacy of parties, confidentiality of information, all will be that in the flow of the EA proceeding. So EA proceeding is proved to be more transparent than the domestic court proceeding, since most arbitration rules stipulate that the prospective arbitrator will have to disclose circumstances that could possibly give rise to any doubt with regard to their impartiality and independence. Even after such a declaration is made by the emergency arbitrators, the parties are entitled to question and challenge the appointment of the arbitrator. They also not allowed to participate in a future related arbitration regarding the said dispute. So no such challenges can be made before the domestic courts. But courts are generally associated with the perception of biasness, especially in cases where one of the parties is a national of the jurisdiction of the said court and the other is a foreign entity. So additionally, unlike emergency arbitration, judges of domestic courts may not have the specialized legal or technical knowledge which required to decide a particular dispute. So this is all about the benefits of the emergency arbitrators. Now, what will be the recognition of emergency arbitration in India? First, if we talk about the interim measures. So while international arbitration practices were codified across various statutes and rules, the lack of any regulation for interim measures called for an amendment, which can be introduced under the unilateral model law on international arbitration in 2006. So, though this revision was aimed to promote greater efficiency in international arbitration. So, what is the interim measure? Interim measures can be described as the grant of temporary relief, which will be delivered by a court or the arbitration tribunal, so they can protect party rights prior to the final award. So, in most of the cases, interim measures are designed with an aim to effectively minimize the loss, damage, or prejudice before or during arbitral proceedings, or to complement the enforcement of the final award. So, with the development of international arbitration as an efficacious alternative dispute mechanism, the need for interim measure has also increased. So, in our 1996 Act, the grant of interim relief, the grant of interim measures is primarily located under two provisions, that is Section 9 and Section 17. As in Section 9 provides power to the court to grant interim measures, while Section 17 equips the whole tribunal with similar powers. So these two provisions have adopted and in consonance with the Article 9 and 17 of the unilateral model law. So what will be these sections we will discuss in detail, that is Section 9 first. This Section 9 provides that a party may, before or during the arbitral proceeding, or at any time after the making of the whole arbitration tribunal, approach the court to seek an interim measure. So a party may approach the court for protection with respect to matters which are given in the provision, also for the interim custody, or they can secure the amount in dispute, or any other thing they can think that which will be just convenient for the court. Also, this section provided that the court shall have the authority to enforce its order as any other competent court. So, Section 9 becomes the primary choice for the parties that seeks to invoke the mechanism for their interim measure. They can invoke the interim measure on so many grounds, for example, the pre-existence of an arbitration agreement or an arbitration clause, a dispute between the respective parties over the subject matter of the contract, which must be referred to the arbitration, or their manifest intention of the respective parties to take recourse arbitration at time of filing, or we can say that the subject matter of the dispute must fall under original jurisdiction of the civil courts. So, Section 9 provides the court with the power to grant interim measures during the arbitral proceeding as well. The amendment which we done in the 2015 brought clarity to the position of the law in this regard. They have inserted subsection 3, it is which said that the arbitral tribunal has been constituted. The court shall not entertain any application for interim measures unless they find that the circumstance of the court, any case, may come unto the remedy under Section 70, which make them ineffective. So the legislature attempt to align the actual intention of the provision and its practical application. These amendments, legislature wants to minimize the role of the court in arbitration, furthering that they can form a proper arbitration regime. But what is this Section 70? We are talking that they can get the remedy under this. So what is this Section 70? Actually, before the amendments done in the Act in the 2015, the statute had failed to incorporate any provision for the arbitral tribunal to enforce its order, rendering the mechanism under its completely ineffective. The only statutory backing that the tribunals have that such order was to be found under Section 27, subsection 5, which provide the repercussions for failing to observe the orders of the tribunal, which may ultimately leading to contempt. So even under this provision, the arbitral tribunal would have to seek the assistance of the court so they can enforce their order. In case of failure to observe the order or a refusal thereby, the arbitral tribunal would have to present a case and seek the assistance of the court in deciding the defaulting party, their disadvantages, and their penalties and their punishment. There is famous case of that Alka versus Shamshul. In this case, Supreme Court has said that the Section 27, subsection 5, empowered tribunals to make representation to courts for contempt of its order. The court further held that the case be remanded to the High Court to decide the alleged contempt, so they can, on the basis of the facts and the interpretation of the statute in question, which can determine the defaulting party's repercussions for the contempt. So there was a clear distinction between the order of the arbitrator and the court, and only the latter was empowered with the authority to enforce its order, which we have given in the section 9. So when there is an absentees of section 17, so defaulting parties had failed to observe the orders of the arbitral tribunal could not be penalized either under the Contempt of Court Act or in the CPC, or as an arbitral tribunal, we treat it as a court. So this 2015 amendment, which I am talking about, eliminate this disparity, and they bring out the section 17 at par with section 9. They inserted subsection 2 under section 17, which stipulates that order passed under section 17 shall be deemed to be order of the court, and it shall be enforceable under the Code of Civil Procedure. So it may seem they have take out that problem in the which they are faces in the 1996 Act, and the amendment was done, and they answer all the problems which is mainly regarding their enforceability. So this 1996 Act does not explicitly state the actual procedure for enforcement of order which will be issued by the tribunal. They leave the enforcement on the CPC upon their several interpretation, whether that be enforced by the section 94 of the CPC or the section 151 of the CPC with the help of the rule 102. So ultimately, the interpretation of CPC is determined on the basis of the subject satisfaction of the courts. So that impact of such interpretation of the whole provisions and enforcement under the CPC will be deal with the interim measures granted by the arbiter, does not mention the concept of the emergency arbitration. This absence has resulted in parties arguing for the non-recognition of whole mechanism. Also, they give such objection to prevent such objection. Certain recommendations have been made by our various law commissions and the Ministry of Law Justice. So let me discuss what are the recommendations given by the various law commissions. The 246 Law Commission report, which is chairman by the Justice A.P. Shah, they said, and they give the legal sanctity to the rule of the institutional arbitration. They recommend that the several amendments need to be made to the 1996 Act, so they can incorporate the concept of emergency arbitration. They also suggested that the High Court and Supreme Court promote and encourage the concept of emergency arbitration mechanism, and they have to take some effective steps to refer disputes to the institutional arbitration. Also, they had strongly recommend that that appropriate amendment to be made to the definition of the tribunal, and the provisional explicitly include the emergency arbitrator under its umbrella. So this amendment would come in light by recognizing the arbitration institutional rule, whether it is Singapore or the MCIA, which provide the rules and regulation for the emergency arbitrator. But Again, the government did not incorporate this recommendation under the 2015 amendment or the 2019 amendment. They have failed to provide statutory support to the concept and mechanism which we are given in the emergency arbitration in India. Another recommendation given by the high level committee report, they also were very pro arbitration initiative they have started, and they recommended so many things. They prefers display toward the ad hoc arbitration over institutional arbitration in India. So these of the mechanism has its own set of advantages and disadvantages which they have gone legal. So they have also recommended, they recommend theoretical and practical concerns regarding the nature of whole emergency arbitration mechanism decision, that whether it can be called as an award or an order. So international community is itself divided on the issue, whether a decision on interim measure can qualify as an award. So many arguments of happen on that point, that interim measures do not resolve any substantive dispute between the parties and their finality, and so we cannot represent an award. Or in a reply to some person has said that jurist or scholar said that its primary purpose to ensure the certainty and effectiveness of the agreement, so they can arbitrate and ensure certainty and effectiveness. So does not explicitly limit such nature of award. Also, it's refrain from imposing such limitations. So these all the discussion was going between the scholars regarding the emergency arbitration. Now, what will be the take of our India to regarding to the emergency of arbitration? There are several rulings which has been given in the case of HSB versus Avitel. That case, in this case, the Bombay High Court was the first case to deal with the recognition of emergency arbitration in India. The seat of arbitration in this case was the Singapore arbitration, which governed whole arbitration proceeding. So the petitioner had invoked the whole mechanism, emergency mechanism, arbitration mechanism, and that resulted in the order by the emergency arbitrator. So they filed a petition under Section 9 of the 1996 Act to enforce that order under Indian law. So this issue that the court had to resolve whether Section 9 of this 1996 Act this fall under the foreign seated arbitration or not. They refer the case of Balco, that is the famous case of the Bharat Aluminium case. In this, court noted that since the argument between the parties was entered into before the decision in Balco and said decision applied prospectively, the ratio of the decision would not apply to this case. Also, the arbitration agreement between the parties specifically excluded the applicability of Section 9, except applicability of whole Part 1, except Section 9. So it is concluded that the parties had undoubtedly chosen to retain the applicability of Section 9. So the court in this case delivered an order in writing, and they reflect the decision of the emergency arbitrator. So court did not directly engage in whether the concept of this emergency arbitration mechanism recognized under the India or not under the section, or the order to pass similar relief under Section 9. They just implied that the emergency arbitrator orders were recognized and deemed relevant by the Indian courts for granting urgent interim order, which can, as long as is come under the Section 9 to the case. There is another case that is very famous case after the HSB case, that is a Raffle Design International Limited case, which is mostly called by the Raffle Design case. In this case, again, the seat of arbitration is Singapore, and petitioner had attained an emergency arbitration order from the emergency arbitration under the Singapore rules. Unlike HSB case, in this case was entered into force after Balco. This case has come after Balco wala case, and the parties had not specifically agreed to govern by Section 9 of the 1996 Act. So in this case, the respondent argued for the non-manageability of the petition due to the foreign seat of the arbitration. So this court took recourse to the 2015 amendment, which came into the effect after the decision in HSB. Also, it amends the position which is laid down in the Balco case. In this case, they said that the provision of Part 1, including Section 9, shall be applicable to the international commercial arbitrations, even if the seat is outside India. So, court have examined the purpose behind that amendment, which is come under the Section 2 of subsection 2, which the rationale behind such an amendment was to enable a party to approach the Indian courts for their interim relief in respect to arbitration seated outside India. It also brings the 1996 Act with the consonance of the unilateral model law, which permits Article 9 to be applied to a foreign seated arbitration. So before this amendment, an Indian party in absence of a specific agreement would have been prohibited for seeking interim measures from Indian courts. So all these raised governed concerns since Indian parties were not unable to obtain interim relief from the courts if the property or assets of the foreign entity was located in India. So Indian party would have to apply to the court of the country in which the seat of arbitration is located, and by the time the property or assets were usually removed or transferred by the foreign entity. So this amendment under Section 2 recommended to rectify this situation and brings the 1996 Act as per the foreign legislation. So also, court observed that the Rule 30 of the Singapore rules, a party could also approach the judicial authority for interim measures. So they have come to the conclusion that parties had agreed that seeking an interim measures from the court would not be incompatible with the arbitration procedure. So parties had not through agreement prevented the application of Section 2 of the 1996 Act. Court also noted that the enforcement mechanism under Section 17 would not be available to the parties due to the foreign seat of arbitration. So all these in circumstances, the party can either file a separate suit under CPC to enforce the order, or they can file a petition under Section 9 in this case. So court said that the Section 9, the court will consider a request for the interim relief independent of the emergency arbitrator order. And Section 9 could not be used to enforce this emergency arbitration order. And court will independently apply its mind and grant the relief. So unlike the HSB case, which delivered a similar automatic relief to emergency arbitrator order, they invariably enforce the court in raffle design, which sought to independently review the case and deliver its decision. So ultimately, if we conclude that the cases dealing with the international commercial arbitration, even with a foreign seat, the parties would have recourse to Section 9 of the 1996 Act to obtain the interim relief. However, prior emergency arbitration order rendered by the tribunal would not be relevant to determination of the court and cannot be enforced under Section 9. So it will be nullify the whole relevancy and de-recognize prior decision of the emergency arbitration in foreign seated case. The last case which I want to discuss, which is a very important case and related to emergency arbitrators, that is the Amazon versus the Future Retail. In this case basically cover a different sphere of the recognition of emergency arbitration in comparison to raffle designs or HSB, since it dealt with the domestic seated arbitration in New Delhi. In this case, the entirely Part 1 of the 1996 has applied. The parties had engaged in the Singapore emergency arbitration that delivered an emergency arbitrator order. So due to the domestic seat of the arbitration, the petitioner directly approached the court under Section 17 and under Section 151 of CPC to enforce the said order. However, the respondent raised objection, stating that emergency arbitrator is not recognized as an arbitrator under Section 2. Also, an emergency arbitration order is not recognized an order under Section 17, and so we cannot enforce under this 1996 Act. So in this case, Delhi High Court provides freedom to the parties to authorize any person, including an arbitral institution, to determine their disputes. Also, they had given stipulates that the agreement to authorize an institution would include the arbitral rules referred in the agreement. Also, this permits the parties to agree on the procedure to be followed by the arbitral tribunal. So, through the whole operation, the court observed the parties had incorporated the Singapore rules under the arbitration agreement, and thereby they had agreed to be bound by the provision regarding emergency arbitration. So, court held that emergency arbitrator will fall under the definition of arbitration under the section 2 of 1996 Act. Also, they viewed that its current framework was sufficient to recognize the concept of emergency arbitration, and no amendment as suggested by the Law Commission or committees were required. Court also concluded that emergency arbitrator order was an interim order of an arbitral tribunal under section 17, which can be enforceable under section 17 of this act. So this decision in Amazon was appealed before the Supreme Court, where the court made observations that were on a similar lines on those of the High Court. This emergency arbitration order make in domestic seated arbitration is currently recognized under section 17 of 1996 Act. On the other hand, if emergency arbitration order delivered under a foreign seated arbitration dealing with all the international commercial arbitration, as we observed in the Raffle design case, do not enjoy such recognition under section 17 due to the inapplicability of part 1. So parties would require to approach court under section 9 or file a fresh suit under the CPC. So while determining the claims under section 9, the EA orders are not recognized or considered by the courts and cannot be directly enforced under this mechanism, which only resulting order of the court under section 9, which will be based on the independent application of mind, which is recognized under that said provision. So overall, this is from my side that all the we have done regarding the emergency arbitration procedures in India. If anybody have any questions, kindly address to me.
Thank you so much, ma'am. Indeed, this is a very informative session. Even the people.
Again, let me wait. You are not audible.
Yes, sir.
Yeah, ma'am. Ma'am, thank you so much. This was indeed a very informative session. Even the people find it very informative. And we have got few questions. If you permit, I would like to ask you.
Yes, please.
Yeah, ma'am. So the very first question from the viewers are, does the arbitration procedure is better than the traditional procedure of the courts?
Okay. So this question is very much dependent on the facts of the case, and we already discussed that why the arbitration should be take one step ahead against the litigation, because it is more affordable, it's less expensive, it takes less time, and it allows for more privacy, and it is more cooperative process. So yes, I believe so that the arbitration is can be choose against the traditional procedure of the courts.
Thank you, ma'am. The second question is, what are the biggest concern in emergency arbitration currently and in future?
The biggest concern, which I can say, that the recognition and enforceability, which is the main concern. What second concern can be the binding nature of the emergency arbitration orders, or the certainty of the some sections of the non-compliance. So all these are the major concerns regarding the emergency arbitrations.
Thank you, ma'am. The third question is, what is the role of judiciary in emergency arbitration?
Okay. For this, role of judiciary is different on everything. That is the whether it has the give the effect, because in the case of the Amazon, we also see that that how it is effectively that they have interpreted that now the emergency arbitration, if the seated in and the seat is in India, they can be, include in the emergency arbitration, can be awarded, and it is a practically yes. So I can say that role of judiciary is depend on enforceability, whether then it can be yes, the role of judiciary is here because certain time to time we need that their help.
Sure, ma'am. Thank you. The last question is, what are the changes required in CPC to enforce arbitral award within reasonable time?
What are the
Ma'am, just to reiterate, what are the changes required in CPC to enforce arbitral award within a reasonable time frame?
I believe there are so many changes which we required in the CPC for so they can incorporate according to the let me think CPC. Any provision for its PG disposal is very much required in the arbitration proceeding. So we just not need to overhaul the system at the level of legislation, but we need to seriously rethink to required on the procedural level. So we can begin by increasing the number of benches for disposal of execution petition in a time-bound manner, or we can has been can given the timing the procedure which is provided in the CPC, specifically the execution of arbitral awards. So government of India can also they have already constituted a committee for suggesting reform to the Arbitration Act. So it is very imperative that the committee seriously consider the issue of delay in execution of all the arbitral award, which truly brings out the reforms in the arbitration landscapes of the India.
Sure, ma'am. These were few questions which the audience raised. Now, in closing, we extend our heartfelt gratitude to you for accepting our invitation at the very outset and delivering such an informative session. We trust that the audience found it very interesting and knowledgeable at the same time. Once again, ma'am, thank you so very much, and we anticipate the opportunity to host you again, ma'am. Thank you so much.
Thank you so much, Tarang. Thank you so much, Ayush, and best of luck for your Just Corps. And maybe we will meet again in the future and some new interesting concepts. Thank you, audience, and thank very best of luck to students.
Thank you, ma'am.